Howdy, this is Brian Foley. I am your favorite Montgomery County criminal defense attorney. And today we're talking about a Court of Criminal Appeals case, Zapata versus State. It's kind of an interesting case. The short version of this is, can the judge make a finding of family violence during a plea bargain when the defendant is accepting a deferred adjudication community supervision plea? And the answer is yes. The Court of Criminal Appeals ruled on this because some other courts had found that they couldn't. There was, I guess, a clever defense attorney who wanted to appeal this, wanted to get some kind of written opinion on the matter. And during a case of his, he had a client plead guilty to deferred adjudication probation, and the judge was asked by the prosecutor to make an affirmative finding of family violence. And this defense attorney said, you can't do that because there's no evidence supporting that, where it's just the plea of my client. It's a deferred adjudication, and this is not a judgment. And it says in the code that the only time a judge can add a finding of family violence is to a judgment. Well, an order deferring the adjudication isn't actually a judgment. So the courts took this up on appeal. The trial judge actually allowed the defendant to appeal that particular issue so they could get some clarity on it. It went all the way up to the Texas Court of Criminal Appeals. And very recently here, Zapata versus State being decided says the judge can make this finding of family violence. It's important because a finding of family violence on an assault case or any charge under Chapter 22 can be used to enhance a criminal offense. So if you have, for example, a prior conviction for Chapter 22 terroristic threat, and there's this family violence finding, or the prosecutor can go back and prove that it was between a family member, then you may be charged in a new case resulting in bodily injury against a family member. You could be charged with a felony instead of a misdemeanor. Typically, if you have bodily injury, meaning any kind of pain or mark that's caused, and you cause that to a person who's a member of your family, you are in a dating relationship, or you live with, so college roommates would count, then that's a family violence case. If you have this prior conviction and you cause bodily injury to somebody like that, then it can be used against you to enhance your new offense to a third-degree felony. So a lot of times the way prosecutors prove that is there's a family violence finding in the documents or the papers of the court, as they called it in Zapata versus State. The papers of the court would include a deferred adjudication plea. So can a judge make this finding of family violence in a deferred adjudication plea? Everybody in criminal law kind of knew this before the case was decided. Yes, it was a sort of a clever argument, but the Court of Criminal Appeals has come down and said, no, that's not going to stand. Judges can make this finding. So you should know that even if you get a deferred adjudication, even if the case is dismissed at the end of deferred, it can still be used to enhance a future family violence case. And that's why it's so important to get a good attorney on these. Thanks, everybody, for listening in. If you like what you heard, you want to see more of these, don't forget to like and subscribe, ring the notification bell, and we'll see you next time.